Honorable, the Supreme Court.
Morning, everybody. Please be seated. Before we call the case, I want to say the court is very pleased to be back at Vermont Law School for the arguments this term. It's been 3 years since we were here last. There's a lot of water that's gone under the bridge, so to speak. So we're very glad to have this opportunity to sit. I want to mention the court's thanks to all the folks who have been instrumental in putting this together, getting us here. There's a tremendous amount of detail that goes into this. Thank you, all of you, from the court, from the law school, who have helped in that regard. So please go ahead, call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled AB versus SU, case number 22 AP 200. Representing the appellant, SU, is attorney Evan O'Brien. Also seated at counsel table is attorney Tristram Coffin. Representing the appellee, AB, is attorney Thomas Nuovo. Representing the intervener, State of Vermont, is attorney Rachel Smith.
All right, thank you very much. Counsel?
Good morning. May it please the court.
Good morning.
Evan O'Brien for the defendant appellant. When the legislature in 2019 amended 12 VSA Section 522 and purported to revive previously time-barred claims for what the law now calls childhood sexual abuse, it crossed an important constitutional red line. To be sure, the legislature can fashion rules of general applicability that apply prospectively, and it did so when it amended Section 522A by abolishing the statute of limitations prospectively for future cases. The legislature cannot...
Mr. O'Brien, the constitutional violation that you allege is the violation of the due process?
Yes, Your Honor.
And would this be substantive due process?
It's not substantive due process because it's a vested rights problem. And the vested rights doctrine dates back to Bates versus Kimball in this court, an 1824 decision. The doctrine predates the advent of the substantive due process doctrine, which is a doctrine that arises after the ratification of the 14th Amendment in 1868. It comes up in Lochner and has a modern iteration as well. This is not a substantive due process case because the vested rights doctrine does not mean that all Vermonters have an individual unenumerated right to assert this particular defense or any particular defense. The vested right only attaches when the legislature enacts a statute of limitations. It applies to a case that arises thereafter, and the statute lapses. And that's exactly what happened here when, by any measure and any calculation, the statute of limitations attaching to the incident that's described in the complaint lapsed decades ago.
So vested rights, from your point of view, doesn't have anything to do with whether a claim has been filed, whether there is some transactional relationship that your client was engaged in at some point prior to the amendment of the statute?
It does not, no, it does not necessarily depend on there having been a claim that was filed and already adjudicated. I would cite the court to the Utah Supreme Court's recent decision in Mitchell versus Roberts for a real-life contemporary illustration of that principle. There was no adjudication of the claim that the plaintiff raised in the Mitchell versus Roberts case until after the Utah legislature in, I think, 2019, 18 or 19, enacted a statute purporting to revive time-barred claims so that that plaintiff could file suit. And that's what happened in that case.
But I thought under that Utah case, there was a long line of authority preceding that in the state of Utah that talked about vested rights and specifically the statute of limitations. We don't have that here, do we?
So we don't have the same line of cases that the Utah Supreme Court had prior to Mitchell versus Roberts. I would agree with that. But I don't think that the case law that Utah had preceding Mitchell versus Roberts is all that dissimilar from your court's case law. So if you'll consider, in the Mitchell versus Roberts case, the first citation for vested rights that the court gives was a case called Handy's Estate in the late 1890s in Utah. And that was a case arising out of a legislative amendment that allowed claimants to bring claims against a decedent's estate that were barred under the previous law. In other words, the facts of that initial case in the Utah line of cases was very, very similar to Bates versus Kimball, to Staniford versus Barry. This court's case is from the 1820s.
But that's more of a substantive rule, isn't it, in that case, than it is a procedural rule? I mean, you would agree, wouldn't you, that the statute, the particular statute that we're talking about here, in Title 12, is procedural. It's more procedural, certainly, than it is substantive. It's not a statute that includes a claim, as the wrongful death statute, by comparison, does, where it sets a limitation, a time limit, of when the claim can be made, but it also articulates a specific claim. And that Handy case in Utah, from my understanding, is more of a substantive, reflects on more of a substantive type of statute than a procedural one. So it's very different than what we've got here, I would think.
I'm not sure I agree with that, because 12 VSA Section 522 was originally enacted in 1990. And what the legislature did in 1990 was not simply amend the statute of limitations from 3 to 6 years. It actually created a heretofore unknown tort called childhood sexual abuse. So it actually was substantive in the sense that it created a new tort, kind of like the wrongful death statute, where you needed to actually have a statute in order for that kind of tort to be created. It was not a common law tort. So too here, childhood sexual abuse is not a common law tort. There were common law torts that preceded the creation of that tort, battery being one of them, probably the main one that would be known as common law. But childhood sexual abuse was created in 1990 as a statutory tort in the very same statute, Section 522, that addressed the statute of limitations. So to the extent that the appellees have drawn the distinction between a revival of a common law claim that resides in a separate statute or separate statutory section from the statute of limitations, that analogy actually doesn't work here, because since 1990, childhood sexual abuse, the contours, the elements, the liability itself, has been defined by the legislature within Section 522, as has the limitations period itself.
So did the 2019 amendment include the enactment of any new claim itself?
It did not enact a new claim in the following sense. childhood sexual abuse remained defined within Section 522. I should add, I don't know how much of interest this would be to your question. It did add an additional definition to what constituted childhood sexual abuse. So before 2019, sexual exploitation of a minor was not one of the enumerated statutory crimes that fit within the definition of childhood sexual abuse. In 2019, the legislature did add that to the list of crimes that were within the statute, but otherwise, the definition didn't change.
Is 522 constitutional without subpart D?
Oh, no question about it. It's completely constitutional without subpart D. Subpart D is the entire problem with the case here. And that's why I would really draw the distinction between what this court in Bates versus Kimball said was a legislative act, which is a predetermination of a rule that operates in futuro, applies to prospective cases,
So-
and a
I'm sorry, so Councilor O'Brien, I just wanted to follow up with the Chief Justice's questions regarding the Mitchell case in Utah. So I read with interest the case law in Utah, which is robust, prior to the change in the statute. We don't have that case law here in Vermont. What I found in the reasoning in those Utah cases was that it was really based mostly on stare decisis. Am I missing something here in their reasoning that you're asking this court to adopt?
So in Mitchell, the Utah Supreme Court begins its opinion with stare decisis, no question about it. And the court determines not to deviate from the precedent. So I certainly agree up until that point with you, Your Honor. But what the court in Mitchell does, which I think is significant and which I think the trial court failed to notice or appreciate, is that the court pivots and says, we could stop here and rest our decision on stare decisis, but we're actually not going to stop here. We're going to go further, and we're going to look at the rationale. We're going to look at other sources like
See the time is being displayed on the side.
Yeah.
Is it different than the?
I don't have the red light.
With a light.
I want to make sure you're aware of it.
Thank you, Your Honor, yes. The court looks at historical sources, looks at other sources, including U.S. Supreme Court cases, looks at treatises like the Cooley Treatise that we cite. So I think that Mitchell, while it's true that Mitchell could have stopped at stare decisis and said, we're just going to stick with this, we don't have a good enough reason to deviate from it, the court went a great deal further than that and provided some real grist, I think, for this court to look to in order to adopt that reasoning.
Okay, thank you.
Can
Can I ask a question before you go on?
Yes.
In our case, Flint versus Department of Labor, didn't we in part resolve this issue by indicating that a statute of limitations is not a substantive right?
I don't think the court has resolved this issue either way. And that's, I think, a point of disagreement among the parties here. The court had the opportunity to do that in its early cases, particularly Lowry versus Keyes and Briggs versus Hubbard in the
Well, this is 2017.
Sure. And in 2017, 1 VSA Section 214 was fully in effect, which provided a statutory rule, a clear statement rule of construction that provided that statute of limitations could not operate retroactively. We didn't have this statute here. That was a 2019 statute. So I don't think that this court has, shall we say, indirectly or subtly answered this question before. I don't think it has. And I think this is the occasion that the court has to finally answer the question that the court didn't answer in Lowry versus Keyes and Briggs versus Hubbard in the 1840s.
Does it make a difference that the legislature made this amendment retroactive?
It makes a difference only in the sense that the court cannot avail itself of statutory interpretive canons like constitutional avoidance to avoid answering the question. The legislature made clear that the statute is retroactive. Thus, the court now has to determine whether that's constitutional. That they made it retroactive, I think, does not mean that the court must abide by that determination. It is this court that has to say what the law is, and statutory rules like Section 522D that are inconsistent with the Constitution are inoperative and void and have no part in the rule of decision in a case. If there are no further questions, I'd like to reserve the balance of my time.
Okay, that's fine. Thank you very much. We'll hear from counsel for the appellee. Are you, I assume, both, you're splitting your time? Yeah?
Yes, Your Honor, we will be splitting time this morning.
Okay. So please come on up.
Thank you, Your Honors. Rachel
Good morning.
Smith for the state of Vermont, and I will be splitting time. I will be arguing why defendant's claim fails because the statute has a rational basis, and my colleague, Mr. Nuovo, will be explaining why defendant's claim fails because there is no property right to which due process protections attach. May it please the court. Defendant's claim fails because even if a statute of limitations defense was a property right, defendant's argument that due process protects that property right is a substantive due process argument to which rational basis review applies. And this statute has more than a rational basis. This statute accounts for the many factors that can delay reporting of childhood sexual abuse, which can include that abuse can cause alcoholism and other substance abuse problems, depression, PTSD, that many survivors repress their memories of the abuse as a coping mechanism.
So are you suggesting that if we had a similar statute that applied to breaking and entering, that the result would be different?
Well, if it were applicable to a criminal statute, then the ex post facto clause would apply, but that doesn't apply to civil statutes.
No, I understand that.
So in light of all those,
So, Ms. Smith, you think that this is a substantive due process argument?
so if it is a procedural due process argument, it fails, and if it's a substantive due process argument, it fails. And the reason why it fails if it's a procedural due process argument is that it's a challenge to legislation. And in a procedural due process to a legislative decision, the legislature's consideration provides all of the process that is due, so the claim fails. If it is a substantive due process, which most of this court's sister courts analyzing similar claims have held that these claims are substantive due process claims, then it fails because there's no fundamental right at stake. No one is arguing that a statute of limitations defense is a fundamental right. So under both the Supreme Court's due process case law and under this court's case law, rational basis review applies, and this statute has more than a rational basis.
How does a lawyer ever properly advise a client if this statute is constitutional? I'm concerned about the beginning and the end here. A client comes into the office and says, this is what has happened, and how does the lawyer respond without knowing that there's some finality here?
So a few responses, Your Honor. The first is that rules of procedure change. So no one can count on rules of procedure staying the same. And then the second is that even if a statute of limitations defense is a property right, all property is held subject to the police power. And this court has held many times that the legislature has broad authority pursuant to the police power to legislate for the public good. And substantive due process provides an outer check on legislation, ensuring that it doesn't arbitrarily deprive people of property. But beyond that, our Constitution vests that decision about what the public interest is and how to further the public interest with the legislature. And then one final note on how a lawyer should advise a potential client who says, I sexually abused a child in the 1980s, is the claim foreclosed, is that prior to the amendment in 2019, there was a discovery rule. So for example, in Barquin, which was decided by the District of Vermont, that was a claim brought under the 1990 statute of limitations, and the court held that the over 40-year-old claim there could proceed under the discovery rule. So a defendant would have no way of knowing under the discovery rule whether their victim would in the future realize that they have psychological problems, would make the connection between those psychological problems and the abuse that they suffered as a child, and whether accordingly the statute of limitations would begin running in the future when that discovery was made. So there is no reliance interest really at stake here.
Ms. Smith, what do you think the distinction is between a vested right and a fundamental right?
So a fundamental right is a right like the right to marry that this court has held is intrinsic to the ordered conception of liberty. A vested right is a property right when we're talking in the due process realm. Vested rights are sort of a loose term that can apply to a lot of things, and this court has used them to refer to rights that were adjudicated pursuant to final judgment. So that is the sort of vested right that this court was referring to in Bates v. Kimball. And Bates v. Kimball is still good law. This court can't, or the legislature cannot reopen final judgments of a court because that would violate separation of powers. This court recently reaffirmed that. The Supreme Court reaffirmed that in Plout v. Spendthrift Farms. So that principle, still good law, but it is inapplicable here because there is no final judgment adjudicating the parties' rights here. So finally, while defendant attempts to cast Section 522's revival of claims as radical, it's not. For example, the claim here is 37 years old. The courts of Delaware, Connecticut, Massachusetts, California, New York, when considering claims under their state due process clauses that followed the federal due process clauses, whether statutes reviving claims for childhood sexual abuse violated those due process clauses. And all of those courts were considering claims that ranged from 32 to 45 years old, and they all held that those claims were constitutionally revived under their due process clauses. So this case is not an outlier, and based on those cases, the Vermont legislature correctly determined that it was well within its power to revive the claims of sexual abuse survivors like the claim alleged here. And with that, if there are no further questions, I see the
Okay,
end of my
thank
time.
you. We'll hear from co-counsel for the appellee, please.
Thank you, Your Honors.
Good
My name is Tom Nuovo, and I have the privilege of representing the plaintiff in this matter. There is no vested right here, and I think this court has consistently held that there is no vested right in the statute of limitations, and I'll refer the court to Lillycrap versus Martin, which this court decided in 1989, and there's a wonderful quote from that case that says, although a vested right, and this is at page 78 through 79, although a vested right is property and is protected from arbitrary interference, the appellant has no property in the constitutional sense in any particular form of remedy. All that is guaranteed by the 14th Amendment is the preservation of his substantial right to redress by some effective procedure. And that is exactly what this statute does. It allows, he still has the rights under the Article 4 to a procedure. And it's that procedure that they're challenging here. Unless there is some vested right that they can point to, then they have no violation of Article 4. Now, the defendant points to a bunch of early Vermont cases, but all those Vermont cases, a lot of them deal with two specific issues. One is they deal with the fact that prior to the Vermont adopting its constitution, a lot of constitution, and this goes back to Calder, which the United States Supreme Court decided in, I think it was 1798. And in that case, it had to deal with, it discussed the fact that a lot of cases were being overturned by legislatures because legislatures had the authority at that time to act as a judiciary and hear cases even from the beginning. There was no overlapping there was no constitutional difference between separation of powers in some states, such as Connecticut at that time. And Bates v. Kimball is recognizing that separation and saying, no, if there's a judgment, that's final. The legislature can't go back and change what happened there and create that right. Lowry is similarly, and I really emphasize the dissent by Justice Bennett in there, because even back in 1842, Justice Bennett is clearly stating that there is no objection to a statute of limitation that is retrospective in its operation or in its provisions. So the court has consistently recognized the difference in ability to go back of the legislature to go back and change a statute of limitation.
So Counsel Nuovo, so your argument to this court is that, excuse me, as a matter of common law, the statute of limitations bars remedies. It does not create rights.
It does not create rights. The right created, there was a vested right when this act happened on my client. Our client obtained a vested right in this cause of action. And the defendant here argues that this is the creation of a new right. It is not. It is just a redefinition of rights that the individual had. We haven't created a right of child sexual abuse. What they've done is they've defined it under the terms of things that existed at the time, such as, and then they refer to the criminal statutes. And both the current, the amendment in 2019 and the original act in 1989 specifically went back, and when they talked about what is child sexual abuse, they talked about things that were illegal at the time and would have also constituted torts at the time. I mean, the fact is that we haven't created an entirely new action for the individual.
Are you taking the position that 522D does not expand any rights?
It does not expand any rights. It creates a remedy. And the whole fact here is that section, Title I, Section 101, which is the basis for all constitutional, statutory interpretation, specifically says in there that that the legislature should follow these procedures unless it clearly indicates that it is not following one of those procedures. And that's what this Supreme Court has also held and stated, which is we're going to look at the clear legislation that was passed. And they clearly in D said, we are not going to follow Section 214, and therefore it is not applicable. I mean, the whole fact that 214 exists should be evidence of, in and of itself, of the fact that the legislature said, well, we have this power to make retroactive legislation, but we're going to limit ourselves here with this statute so that the courts don't interpret legislation retroactively unless we clearly state it otherwise. And that's what this.
But, Mr. Novo,
Yes.
522D, all it does is preclude the defendant from using a statute of limitations defense.
Wait, say that again. I apologize.
It precludes a defendant from using a statute of limitations defense as part of the claim. It's still your burden of proof to show the elements of the offense by preponderance, and unless it's gross negligence. But so you still have the obligation to do it. They just don't have the right, or it doesn't have the right to use a defense of the statute of limitations.
That's correct. So that's the entire point here is that all Article 4 does is provide a procedure. It allows, and a process. It does not, and nothing in here, nothing in this statute limits the process. The burden of proof is still upon the plaintiff to prove their case that it happened and all those items. So that is exactly right, Your Honor. One thing I wanted to, oh, go ahead, did you? Okay. One thing I wanted to point out was that this court had previously addressed the issue of the amendment prior to this case, and in that case they specifically discussed the fact that how far back you could go, and So I think that the court has already addressed the issue that you can go back past a timeframe when they were talking about prior claims of sexual abuse. Finally, okay, 1 minute. So one of the things I think, Doe
You got
versus.
1 minute,
Yeah,
Mr. Newell.
thank you. In Doe v. Hartford, I think that case is instrumental because they really do talk about both the reasoning for it, and it has fairly similar constitutional and historical references to how their statute works. So the only other case I would want to point out is Richards versus Cook, which establishes that retroactive law is that the legislature has the ability to do retroactive law. I think there's plenty of places where the court has done that. In conclusion, I would request your honors that you affirm the decision of the trial court and remand this matter back so that we can have a trial on the merits. Thank you very much.
Thank you. Does the appellant have time?
Appellant has 1 minute and 52 seconds remaining.
Okay. Counsel?
Thank you, Your Honor. I want to hit a couple of the points that the appellees made. Retroactive legislation, as the appellees have characterized it, is not per se unconstitutional. That's not been our argument, never has been our argument. Laws which deprive persons of vested rights are retrospective. That is true. Not all laws which are retrospective deprive persons of vested rights. And it's only those laws, like Section 522, that are unconstitutional. Next, the appellees try to cabin Bates versus Kimball to the factual background of the case, which involved a final judgment. I think that's too narrow a reading of Bates versus Kimball. I think you can divine a broader rule from Bates. In other words, a final judgment is sufficient to confer a vested right upon a particular party, but it's not necessary.
1 minute.
Thank you. It's not necessary, and I think you can look at Lillicrap versus Martin, where a plaintiff acquires a vested right to a cause of action well before there's a final judgment in order to divine that broader rule. Applying a rational basis test here would gut the vested rights doctrine. This court has never applied a rational basis test to a vested rights case. It didn't do that in Lillicrap versus Martin, even though the legislation in Lillicrap versus Martin easily would have satisfied rational basis review. I think if you apply a rational basis test, then Lillicrap and Bates versus Kimball, those cases, which are very significant cases, I think fall by the wayside. There's not a limiting principle to what the appellees are urging here. This is not simply about childhood sexual abuse, which of course is an extremely important topic. But if this is the rule going forward, it applies to all cases, and that's very important to think about the broader consequences here.
All cases involving this type of cause of action, not all cases across the board.
Oh, no, it would involve all cases. It would involve torts, contracts, taxation. People cannot destroy their tax documents after 7 years if this court affirms, Your Honor.
Thank you
But
very
in the
much.
criminal arena, ex post facto serves to protect.
It does, Your Honor. I see my time's expired.
Yes,
Thank
thank you
you.
very much.
Please reverse.
Please call the conclusion of the hearing.
The next hearing for the court is scheduled for 10 o'clock this morning.
Yeah, yeah.
The Honorable, the Supreme Court.
Thank you very much. Good morning again, everybody. Please be seated. Good morning. Please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled State versus Labreck, case number 22 AP 314. Representing the appellant, State of Vermont, is Attorney Evan Meenan. Representing the appellee, Larry L. Labreck, is Attorney Allison Fulcher. Also seated at counsel table is Attorney Alex Dunn for the Office of the Defender General as amicus curiae.
Thank you very much. Good morning again, everybody. Is this the first time you've been at that table, Mr. Meenan? I just am wondering.
I think I was the appellant one time when I was in private practice a long time ago.
Okay, come on up to the podium if you would, please.
Thank you very much. Good morning, and may it please the court. My name is Evan Meenan, and I represent the state of Vermont. In this case, the state respectfully requests that this court follow its recent decision in State versus Young and conclude that the delays in this case, which are largely attributable to the COVID-19 pandemic and appellee's own motion practice.
Let me just interrupt. Can you turn the volume up on his microphone at all? Oh, where? That's great. Thank you very much. Okay.
My apologies. I'll try and use my my outside voice. As I was saying, the state requests that this court follow its recent decision in State versus Young and conclude that appellee's speedy trial rights were not violated. The Defender General's office suggests that such a conclusion would be unprecedented. But what was unprecedented was the COVID-19 pandemic, as this court has recognized multiple times, including in 3 prior decisions in this particular matter. This court's issuance of AO 49 was a reasonable response to that pandemic and did not violate the defendant's constitutional rights. As such, the dismissal of this case after a jury verdict of guilty should be reversed, and this case should be remanded so that appellee can be sentenced for sexually assaulting a 16-year-old girl.
Do you have any insight as to why the court put in abeyance the motion to dismiss for lack of speedy trial and then held a jury trial and then addressed the motion? Is there something I didn't see in the briefs as to why that happened that way? I find that very odd.
The state agrees that that's very odd, and in fact could also be characterized as fairly unprecedented. The state was not able to find anything that prohibits that procedure. However, it does appear to be unusual, and I was unable to locate anything in the record that definitively explained that decision.
Do you agree that it was the fact that there was a motion on speedy trial held in abeyance that gave the court the opportunity to address that after the jury trial, and that Rule 29 is not an appropriate vehicle for a speedy trial claim?
Well, it's certainly the way that the trial court viewed it. My recollection of the record is that there was a motion for a judgment of acquittal, which the court on its own elected to treat as effectively a renewed motion to dismiss. That particular issue was not argued in the briefs, and it wasn't cross-appealed by the appellee. In other words, the appellee hasn't argued, no, this should have been treated as a Rule 29 motion. The state's preference, obviously, is, regardless of which way this court views that procedure, reversal is warranted, especially in light of this court's recent decision in State versus Young. In that decision, this court reviewed the 4 factors that apply in the speedy trial analysis from Barker versus Wingo, and I'd like to review each of those factors now, although they're fully briefed in the state's filings.
Is Barker foursquare with this case?
Well, no, in respect to in a couple of different ways. One, Barker is factually distinguishable. I mean, in that particular case, I think the defendant waited 8 years to have his trial, and I believe that
He was in Paraguay or somewhere during the bulk of that time.
That's correct. And my recollection of that case, I believe, is that the government was less than diligent in pursuing the necessary arrest warrants to bring that matter to trial. This case is much different, however. We're not dealing with 8 years. We're dealing with 45 and a half months.
But we are dealing with someone who's incarcerated.
Excuse me?
He's incarcerated he's incarcerated that time.
That's correct. Mr. Lebrecq was incarcerated the entire time, but that fact is not necessarily much different than the facts in State versus Young, which not less than, I think, 2 weeks ago, this court determined there was no speedy trial violation. In that particular case, the delay was 38 and a half months, and in this particular case, the delay is 45 and a half months.
You have experience in criminal prosecutions, and if you subtracted the time that COVID delayed the case here, would the remaining time be unheard of as far as coming to a conclusion of a case like this?
No, Your Honor, and I think that this court recognized that in its Young decision. For example, in Young, what this court did was it subtracted the amount of time that was related to resolving competency issues, which was not an issue in this particular case, but then it also subtracted the pretrial motion and discovery practice, characterizing it as not necessarily vexatious. I think the same thing could be said in this particular case. So what happened in Young was, after subtracting that time, this court got down to 20 some odd months worth of time that we are talking about for the speedy trial analysis. That is that's very similar in this particular case. So the delay was reduced from 38 and a half months to 20 and a half months in Young. In this particular case, if you carve out the pretrial motion practice, which the state would assert was not vexatious on either party's part, we get down from about 45 and a half months to somewhere between 10 and 19 months, depending upon whether or not you want to subtract any overlapping delays from COVID. So if we're looking at 19 months, that's very close to the 20 and a half months that this court was just considering in Young. And my recollection, I was the attorney assigned to that appeal, was that that individual was also spent a significant amount of that pretrial time incarcerated.
The 10 to 19 months includes deducting the COVID time?
It depends upon how you want to treat the overlap. So for example, if you wanted to just subtract out the time that's attributable to the pretrial motion practice and discovery, we're looking at a delay that's somewhere around 19 months. If you want to say, let's also get rid of any time, any of that 19 months that overlap with delays that were caused by COVID, you get down to about 10 months. So that time period is very similar to the time period that we were looking at in Young. And so as a result, under factor one, as in Young, it does not weigh very heavily in appellee's favor.
But you do concede that there is enough delay here to get into the other Barker factors, correct?
Yes, in this particular case, I think the state has to make that concession. I mean, there's case law that's discussed in both parties' brief that indicates you could get down to around 12 months, and that still may be grounds for warranting the other Barker factors. But that doesn't mean that factor one weighs in favor of a speedy trial analysis, because, for example, as Justice Carroll was asking earlier, this court has found that a year or more to take serious felony cases to trial, unfortunately, is not uncommon in the state of Vermont.
Do you concede that the delay is accountable to the state?
The COVID-19 delays?
The total delay here?
Not the total delay, no, Your Honor.
You do not?
We do not, no.
What about the COVID delays?
The COVID delays, yes. This court has been very clear in at least 3 of its prior decisions in this case, as well as in Young and at least one other case whose name I can't remember, that the COVID-19 pandemic does count against the state in a speedy trial context. But that's not the end of the inquiry. The next question is, well, how much weight is assigned to those delays? And this court has been equally clear that the pandemic was hopefully, a once-in-a-lifetime occurrence. It was unprecedented. We all had to cope. with making certain sacrifices. And as a result, the delays that are attributable to the COVID-19 pandemic were not intentional, they were not malicious, they were not the result of government neglect, and they do not weigh heavily in favor of a speedy trial violation.
I wonder if I
Miss-
might shift, oh,
No,
okay. I wonder if I might shift your focus a little bit here, in terms of the assertion of the right to a speedy trial. There were numerous bail review motions filed in this case, numerous assertions of due process issues. Do you think that that is sufficient to assertion of the speedy trial right, or does there need to be a specific Sixth Amendment claim?
The state's position is that those 12 bail-related motions and the statements made during the 5 bail-related hearings are insufficient to constitute the type of aggressive assertion of speedy trial right that would weigh in appellee's favor.
So are you saying the defendant has to express those words, to actually articulate the words itself?
Yes, that is the state's position, and that's not a difficult thing to do. I mean, when you look at the case law, right, it seems to be different tiers of assertions of a speedy trial right. On the one hand, you have something like a motion to dismiss based on speedy trial grounds. That's somewhere in the middle, it appears. It's not as strong as a specific request that says, pursuant to my speedy trial right, I am objecting to further continuances of the trial in this case, and I would like my trial as soon as possible. That is clear and unambiguous, and that would be an aggressive assertion of a speedy trial right, and it's not difficult to do.
Didn't that
So,
occur-
Mr.
Go ahead.
I'm sorry.
No, go.
Sure.
Yes.
So, Mr. Meehan, you initially requested that this court reverse and remand for sentencing. I'm concerned about the procedural integrity of this case. Justice Carroll asked you if you had any insight as to why the trial judge did not address the speedy trial claim prior to proceeding to trial. So in the motion for judgment of acquittal, I find that even though you did not address, or the state did not address the non-particularized presumptive prejudice, the defense did cite LaFaso, Doggett, at least putting the state on notice that that should have been addressed in the response to the motion for acquittal. You subsequently asked then for, when the trial judge would not permit you to advance the argument to shift the presumption, you then asked if you could address that in the motion for reconsideration, which the lower court denied. So why wouldn't this court, if it were to reverse, not reverse back for the trial court to make its ruling on that factor, the non-particularized presumptive prejudice, and proceed that way rather than go straight to sentencing?
That's a very good question, and it requires some unpacking, if I may. Preliminarily, the state disagrees that the motion for a judgment of acquittal clearly argued presumptive non-particularized prejudice, even though it cited Doggett and LaFaso. In fact, the LaFaso citation makes things even more confusing, because it's insufficient just to look at the pleading and say, oh, they cite Doggett, they must be talking about this type of prejudice. Well, Doggett talks about a lot of things. And if you look at the pin sites that they were using in those citations, they cite Doggett under the first factor, but the pin site pertains to the proposition that that factor is a double inquiry. And then under the fourth factor, the pin site to that case pertains to the claims that the defendant suffered actual prejudice in Doggett. So none of the actual portions of the Doggett decision that were cited had anything to do with presumptive non-particularized prejudice, which is why as soon as the court decided this case on that factor, the state was left scratching its head and saying, well, how do we address this now? And this court has been clear that motions for reconsideration can be used to preserve issues on appeal, which is why instead of filing an immediate appeal, the state filed a motion to reconsider along with a request to extend the appeal deadline. In direct response to your question, if this court were to reverse the trial court's ruling and remand for a new hearing on the fourth factor to give the state an opportunity to rebut this type of prejudice, that is obviously a much more preferred outcome to a dismissal. However, the state's primary position is if you go through and analyze the transcripts, there's more than enough evidence, as the state outlined in its briefs, to conclude that that presumption has in fact been
And
rebutted.
But can I just ask a follow-up, though, to that?
Go ahead.
So you argue in your brief that this court should use plain error as a review if something isn't preserved below. And I agree with that. However, in this, when the burden is shifted, as it is in this analysis, can we use plain error?
Well, the state would assert that the burden has not shifted.
Okay.
And the reason why it has not shifted in this particular case is the same reason why it didn't shift in Young. When the state acts with due diligence in its prosecution, the issue of presumptive non-particularized prejudice simply never arises, the burden never shifts, and it's still incumbent upon the appellee to demonstrate actual prejudice. If, however, this court were to conclude that that type of prejudice did arise, it would not be necessary to turn to a plain error analysis unless this court were to agree with the appellee that the state did not preserve that argument and is raising it for the first time on appeal. The state's asserting that we did not waive that argument because we were not on notice that that was a claim, and we addressed it as soon as we did make that realization in our motion to reconsider.
If it's a non-particularized prejudice, which is something that cannot necessarily be articulated, how do you rebut it?
Well, I think that courts have struggled with that very idea. But the cases discussed in the state's pleadings indicate that the trial court was correct in at least one thing, and that is that you can rely on the actual trial transcripts to try and conduct an analysis as to whether or not the presentation of the defense was actually impaired. And this court has ruled that when prior witness statements from depositions or otherwise are available, then any prejudice from a claimed diminishment of memory is drastically reduced. And we would ask the court to reach that same conclusion.
All right, thank you.
No, just, nobody had no memory of it, they just had a reduced memory. Is that correct from the review of the transcripts?
Well, the state's review of the transcript indicates that no witness lacked any memory relevant to any material factor element in this case that could not be sufficiently impeached or rehabilitated through the use of prior statements. And in fact, what the trial court held was that those statements were available and simply weren't used effectively by the defendant in this case.
But aren't those a showing of actual prejudice?
Well, it's the burden shifting works in this particular way. Absent presumptive non-particularized prejudice, the defendant has to show actual prejudice.
Right.
Once the presumption arises, the state's in the position of essentially having to prove a negative, that there was no actual prejudice. So it does function a little bit like a burden shifting in that way, but technically what you're proving is a little bit different. And that's why I think it makes sense that reliance on the transcripts is important. And for that reason, in this particular case, maybe it was beneficial that the court waited to issue its ruling until after the trial happened.
Okay.
Thank you very much.
Thank you very much. Your time is up. We'll hear from counsel for the appellee, please. Good morning.
Good morning. As a preliminary matter, we're raising an issue not previously raised, but it's important that we do so because it raises a question of jurisdiction. We believe that pursuant to State v. Roy, and the site is 2018 Vermont 67A, and 13 VSA 7403, the state has no authority to appeal a post-verdict order vacating Mr. Lebrecht's conviction. And because of that, we will be filing a motion to dismiss. Concerning the argument as far as speedy trial, the state says that this...
Can you articulate a little more about
Sure.
what you just said?
So this court in State v. Roy found that, that 13 VSA 7403 is the statute that gives the state the authority to appeal. Otherwise, absent statute, the state has no authority to appeal. And in Roy, this court ruled that the state did not have the authority under the statute to bring an appeal from a grant of a motion for judgment of acquittal post-verdict. And in this case, we have the court making a speedy trial determination post-verdict. And we believe that there's no enumerated provision in the statute that allows the state to bring that.
Even though a motion, it wasn't just a motion for judgment of acquittal, there was a pending
I think
speedy
the
trial motion before the trial.
Correct, but there was one filed afterwards. There was a speedy trial motion filed before trial. It was deferred ruling on. There was one filed post-trial, and the court issued its decision post-trial. And we argue that 7403 enumerates when a state can bring it, and it's not one of the enumerated reasons that the state can bring an appeal. There is the provision in there where it says that the state can appeal a dismissal of an information, but we argue that the dismissal of an information is not the same. Once it's post-verdict, you're not dismissing information, you're vacating a conviction. And there's nothing in that statute that gives the state the authority to appeal a case when the court has actually vacated a conviction. And that I will be filing just a motion on that.
I'm going to pivot to something else.
Sure.
Talk about State versus Young
Yeah.
and where that leaves the finding of presumptive, non-particularized prejudice that the court made here.
Okay. So State v. Young was just decided, but State v. Young is not dispositive to this case. They are procedurally and factually different cases. And all speedy trial cases are unique. No one decides another one. They're factually and procedurally distinctly, and they need to be decided on an ad hoc basis. So Young is it's not dispositive and very much different from the case that we have here.
Oh.
Okay. First, we have a trial court deciding in this case that there was a speedy trial violation. We have the trial court actually making that determination.
On
in
factor
Young.
one, to proceed to the rest of
On
the
all of
factors.
it. In this case, the trial court found that every single, we get to the Barker factors, and then yes, after that, every single factor weighs to some degree against or for the defendant. We didn't have that in Young. We have that in this case. Second, and probably the most important thing about this case, is that the state didn't preserve its arguments that it now raises on appeal. They were not presented below, and the state did not argue plain error. And we would also argue that now that in their reply brief, they say they're entitled to plain error, and we would argue that the state is not entitled to plain error, and I would guide the court to its decision in State v. Alcide, where the court found that typically the plain error standard is rooted in the rights of the defendant, and that it's not something that the state is entitled to. So on that basis alone, we'd say that the state has not preserved their issues. This court need not address them and should affirm the trial court. If we look at that preservation issue and we go to the first criteria, the state conceded. In the trial court, they conceded that the delay was 41 months and that the delay presumptively weighs in Mr. Lebrecht's favor. Criteria 3, same thing. The assertion of his right to speedy trial. And in the trial court, the state conceded that Mr. Lebrecht has asserted his right to a speedy trial, and that factor weighs in his favor. And the trial court, in ruling upon the motion for speedy trial, found that it had already determined in an earlier, the very first speedy trial motion that was raised by the defendant, that he had already found that the defendant had asserted a speedy trial right. That was back years, 2 or 3 years before this finding. So the court had already ruled. The law of the case in terms of that, the law of the case was that the court had already found that the defendant had met the third criteria, and that weighs in his favor.
Was this in the October 2020?
That was in the the very first,
Okay.
yeah, as long as it wasn't the bail, but it was the speedy trial, I think.
Right.
I don't know if it was October, it might have been,
I think the ruling was in October.
yeah, right, correct. The second and fourth criteria, the state never argued law of the case doctrine, and it raised it as, for the first time in appeal, and the law of the case doctrine is one of those arguments that needs to be preserved. In the second criteria, the sum of the state's argument below was the factor was neutral. If we look at if we're looking for the reasons for the delay, the state argues that, that 15 or 19 months, and that the defendant is, responsible for a great deal of the delay. It's simply incorrect. The state is responsible from the delay. If we take out the pre-trial of the pre-COVID time period, which the court did, because it's a neutral time period because it's pre-trial practice. The parties are doing what they need to do to move the case along to trial. If we take that away and we take the time period from COVID, which this court has already found is attributable to the state, all the way to the time of trial, the only time frame that is attributable to the defendant, the delay attributable to the defendant, is 1 month. Other than that, that entire time period is attributable to the state. That's 25
But
months.
doesn't Young say that presumptive prejudice only counts against the state in terms of weight if there's been negligence or intent?
Young does that. Young says that, but I don't think Young should, honestly, I don't think that Young should be read that way. Because I don't think that Young should be read that the state always has to have unclean hands for presumptive prejudice to weigh against the state or
I
to,
think there was a qualifier there that says generally.
generally. That's correct.
So there are some
So I think,
exceptions.
yes, I think it should not always be read that the state has to have unclean hands or, but I think there was a finding by the trial court that there was like that COVID, although it's definitely attributable to the state and it's doesn't weigh heavily against the state, there is a sense of inherent negligence. It's not a malicious, it's not an intentional, but it is a negligent part on the state, because the state is responsible for moving the trial forward, to moving the case forward.
Right, but if you're talking about some sort of inherent negligence, it's still a negligence concept, which means that it's a failure to do what a reasonable person
Correct, and
would have
that-
done. What is that here?
In this case, it's moving the case, COVID, the state argued, I believe they said that COVID was unprecedented. And I would say, is it really unprecedented? Was COVID completely unforeseeable? Could courts have done more? Because during the time of COVID, the defendant's constitutional rights don't go away. He still has his constitutional rights, and the
But it
courts
was
still have a duty.
it's a public health crisis where people in touch with each other, communication with each other, become infected from a virus that, if you recall, at the beginning of the pandemic, was killing a lot of people. So the balance between the constitutional rights of defendants like yours, who were incarcerated at the time, and addressing the potential for further communication of this disease in a way that would be, have very extreme consequences. How can you discount any of that?
Well, I don't think you can discount it. We're not arguing that you discount it. But I do think that the court, I don't think it was, that COVID was unprecedented. And I don't think that necessarily that we could have.
What is the precedent before it?
I mean, there was the avian flu, I think, in 2007, which raised concerns with many courts. And there was coalitions that were getting together to, make sure that the courts were going to be in a position to handle if situations like that presented themselves. There was the flu back in the 1800s. I mean, it's not unprecedented that a pandemic could, hit the world.
So I'm curious then about the analysis. So are you saying that it's the states, it should be attributed to the state because the judiciary could have started up trials in the middle of COVID? Or
Well, no,
is it
I-
attributable to the judiciary?
It's,
And
well,
where does that fit
it's the
in
same,
analysis?
right? Isn't that, and that's kind of the interesting thing of a speedy trial analysis, is you have the defendant being responsible for the defendant, yet when you talk about the government, you're talking about the prosecution, you're talking about the courts, you're talking about a whole series.
And you're talking about the defense bar, if I might add.
Correct.
I mean, we had issued rules during that period of time that would have been available to attorneys on both sides of cases if they agreed.
Right.
If
And then
they
the-
agreed. And so we had many cases that were delayed because there was, I don't think there ever was an agreement. But our standard was,
Right, but, and if you had a situation where it was the defense that was, not agreeing to it because of COVID, then yes, it would weigh that, it's the same thing as, conceding into, a delay or a continuation. You have to count that against the defendant. But this court's already found that COVID is attributable, so we don't need to, the COVID is attributable to the state.
well, I think we're talking about weight.
Right,
That's
but
what
I think it
Justice
has to
Keith
carry some weight. It can't be attributable and not carry, because the state is always responsible for moving that case along. And for whatever reason, if it had to, shut down the courts for a while, there is still the argument that perhaps many trials in other counties had already started before they started in this county. So perhaps this, there's fault in that this county more should have been done to moving trials along
Well,
in this
they
county.
were given, he was given trial dates. They kept getting pushed off. There was one issue involving a
Right.
health issue from one of the attorneys, had nothing to do with the defendant. There was an issue involving some witnesses. So there were trials being set for Mr. LeBrecq.
But with the exception of 1 month, those delays were all continuances by the state, which were not, they weren't acquiesced to by the defendant.
Didn't the court find just one, other than COVID, one delay attributable to the state, which is 3 months when the witness had COVID or had symptoms of COVID?
Yeah, and because that was it, and you had the COVID period, you had the 1 month that the defendant is responsible for, and then you had all that time afterwards, and some of that was the 3 months continuance.
I read it was only 3 months.
Well, it was
Didn't
3
the
months.
trial court make the finding that it was 3 months attributable to the state other than COVID?
Right, but then you're still talking about, if you're talking about the start of COVID to when trial came, that 3-month period is in there. And the only time period from that, in that 3 months in there, is 1 month to the defendant. That 3 months is the state. It may have only been 3 months, but you're tagging on top of the COVID delay. So if you're talking about from COVID to trial, there's only 1 month in there then the rest is 25 months, or 56% of the total time that it took to get Mr. LeBrecq to trial is the responsibility of the state.
But the court didn't make that finding. Didn't the court specifically make the finding that delay was attributable to the state due to COVID, and then only another 3 months? It didn't talk about that period between COVID and when the state had to ask for a continuance being attributable to the state, other than talking about your month when you asked for a continuance.
The court did. I think the court looked at the 45.5 months and said the first, 20 months or so was neutral. The court did find that it was a neutral because it was and then after that, the court found everything with the exception of that 1 month was the responsibility of the state. If I could just finalize by saying.
Yeah, please,
Thank you.
sum up, yeah.
This is a case where we have a trial judge who sat on the case through the majority of the bail appeals, all the speedy trial motions, the period when AO 49 was implemented, and most importantly, the trial. Seeing the whole picture through his judicial lens, and then analyzed the speedy trial in great depth and detail, and found the length of the delay, the reasons for the delay, Mr. Lebrecht's assertion of his speedy trial rights, and the prejudice to Mr. Lebrecht all weighed in his favor, to a lesser, greater or lesser degree, but all weighed in his favor. And so for that reason, we would ask the court to affirm the trial court.
Thank you very much. Thank you, counsel. Does the appellant have any time?
No time remaining.
All right, please call a conclusion of the hearing.
The next hearing for the court is scheduled for 11 o'clock this morning.
Thank you both.
Honorable, the Supreme Court.
Good morning again, everybody. Thank you very much. Please be seated. Okay, please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled City of Burlington versus Sisters and Brothers Investment Group, LLP, case number 22 AP 194. Representing the appellant, Sisters and Brothers Investment Group, is attorney Brian Paul Hare. Representing the appellee, the City of Burlington, is attorney Kimberly J. Sturdivant.
Thank you very much. Good morning, counsel. We'll hear from the appellant first, please, of course.
Good morning, Your Honor.
Good morning.
May it please the court, as we just heard, I'm Brian here, representing Sisters and Brothers Investment Group LLP, the appellant here. And I know the procedural history is spelled out in the briefs and the record. Just a few notes about the hearing of the proceedings below with the Burlington Development Review Board. They have, the allegation against my client was operating a private parking lot. I think it's important to note that the phrase doesn't exist and is not defined in the zoning ordinance. In fact, the ordinance does not prohibit the renting of parking spaces and makes no further comment on what a private parking lot is.
Sir, you did not raise that in front of the DRB? And even if you did, you didn't appeal the DRB decision, so have you preserved that for us?
And that's entirely correct, Your Honor. The attorney representing my client at the time was unable to file an appeal for what I've been told are, medical reasons. So yes, the DRB's decision was not appealed, but what I wanted to just point out about that decision was that they didn't make any findings about the number of spaces and when the spaces were being used, and that's what the environmental court spent a lot of time discussing.
But
Go
the
ahead.
specific issue about the definition of a private parking lot
Yes,
has never been ruled on below.
I would agree with that, yes.
But sir, at some point, there was a determination in 2004 that the gas station at the time, the service station at the time, was allocated 18 parking spots for the purposes of having cars that they were working on be there, not to rent out, but so that they could leave cars that needed repair.
That is true, Your Honor. And regarding that 2004 agreement, that was an agreement between the city and the previous owner. And one of the issues, one of the claims of error with the environmental court's decision is that they appeared to have based a large amount of their penalty calculation on this 2004 agreement. City never sought enforcement of that agreement up until 2019 involving this case. And importantly, in 2017, when the gas station use and the repair use ceased, the 2004 agreement became moot because that agreement had to do exclusively with striping, parking spaces, landscaping, for the gas station that was there at the time.
Leaving aside the mootness aspect of this, if I recall your briefing correctly here, you were saying that there was no notice to your client of the 2004 agreement. But I'm having trouble with that because the 2004 agreement was recorded in the land records, and it was recorded on the same day that your client closed the deal. So isn't that notice to the world?
I think it's notice to the world, and I wasn't representing the appellant here at that time, but if a document's recorded on the day of a closing, typically you're not going to update your title on the day of closing. That may be done a few days before.
Didn't the original agreement also require the notice that it had been given to your client with a signature by the seller that happened?
That's correct, Your Honor. the agreement required that the then owner present the agreement to any buyer, and that the buyer sign a page saying that they've received, understood, and acknowledged the existence of the agreement. That never occurred.
And it's also undisputed here, is it not, that the city never sought enforcement of that 2004 agreement against you up until the time that it stopped being a gas station?
That's correct, Your Honor. That's correct.
And would there be a statute of limitations then regarding the 2004 agreement and any of those violations that might be imputed to your client?
We made that argument below, Your Honor, and interestingly, the argument being trying to show that the parking spaces had been rented for 15 years or more. So what the court did, and what I think was possibly an error, was to look at our appellant's photographs for numerous years and state in his opinion that those photographs only showed cars on the lot on the single day the photo was taken. Now, the city had a series of photographs taken on 10 separate days, and somehow the court extrapolated from those that those 10 photographs of 10 separate days taken by the city amounted to 892 consecutive days of parking. So,
I'm going to bring you back to one of my first questions
Yes.
to you. This issue of the statute of limitations was not raised in the DRB, and the DRB decision was not appealed. Is it preserved for us?
it's a good question, Your Honor. What happened shortly after the DRB decision, I think, was June of 2019, and then shortly after that, in August, the North Avenue decision was issued by this court. Prior to that, Burlington did not recognize the 15-year statute of zoning limitations for uses, only for structure and structural issues. So the North Avenue case said that uses are subject to the 15-year statute of zoning limitations. And my argument to the court was we should reopen that DRB proceeding since the North Ave decision came out, a month
You
or
argued
two.
that to the environmental division?
We argued that to the environmental division, and Judge Durkin spent a fair amount of time in his decision basically denying our allegations that we had achieved 15 years of a use, so that we would be subject to the statute of limitations. But the thing here is, for our photographs, he stated that all they show is parking for that single day. But yet the city's photographs of 10 separate days amounted to 892 days. Now, city staff had said at the hearing that we observed no parking on the weekends. So the 892 days is, to me, clearly excessive. Parking is a transitory thing. There weren't people parked here all the time. The city has no prohibition against renting out a parking space, but the environmental court based part of its penalty on income my client received from renting out parking spaces.
You say, sorry to interrupt you, but
That's all right.
you say that the penalty that the environmental court assessed is punitive. What's the legal basis for us to make that determination here?
Punitive because, Your Honor, in my opinion, it doesn't bear any rational relation to the damages suffered by the city.
Is there case law that says that?
The best Vermont case is Heinsberg v. Dunkling, which explores that very issue. And that stands for the proposition that a penalty amount is punitive if it doesn't bear any rational relation to the damages suffered by the.
But he reduced it by a significant, the daily penalty, as I understood it, by a significant amount to, I think, $50 a day, something like that, from potentially 200 or somewhere in that vicinity?
I think 200 would be the maximum.
Yeah,
Yes.
yeah. So why is that punitive under this case?
Well, in the environmental court's opinion, Your Honor, he states that thankfully, the zoning violations did not otherwise cause actual impacts on the public health, safety, welfare, and the environment. So this is basically a case where, you know, it wasn't toxic waste flowing into the ground or you know, uninhabitable accommodations or apartments. It really was a case where there were no impacts, except
But do there have to be impacts? I mean, if he's in violation of the zoning ordinances, the statute allows fines. Aren't those fines for coercive reasons, not penalties? It's, you get your cars moved, or every single day you don't do it, you're gonna have to pay for it. Is that a penalty, or is that a coercive measure?
I would agree with that, Your Honor. I think there's a line, probably a gray line, between a coercive penalty and a punitive penalty. Here, the penalty was $66,759.92 for, you know, for what the city says is a zoning violation. But I go back to the fact that the Burlington zoning ordinance doesn't define or address a private parking lot or necessarily prohibit it. In fact, we have a statement from the city staff saying that when asked, is private parking use prohibited in the city, city staff answered at trial, private parking lot use is not prohibited under the ordinance.
But isn't it, it might not be prohibited, but you still have to get approval for it.
It should still be permitted. And in fact, in the 2002 Burlington ordinance, up until, I think, 2008, a parking lot actually was a permitted use in that high residential zoning district.
But wasn't a significant amount of the overall amount that your client owes, as alleged, for the cost of enforcement, the cost of the individuals who had to go there, the amount of hours that the person put in, the amount of hours that the attorney put into the case, and then the court made specific findings that those costs were fair and reasonable under the circumstances, and review that. So it's not just the penalty on the $50 a day, it's also the cost of enforcement, which is allowable, isn't it, under the statute?
I agree with that, Your Honor. The city had proposed a penalty which equated the cost of their enforcement. The judge went over and beyond that by over $20,000. The $66,000 was not what the city asked for to cover its enforcement costs, which Kim can straighten that out for me, but I believe we're in the neighborhood of $25,000, give or take.
On the cost of enforcement and the penalties?
Pardon me?
On the cost of enforcement and the penalties?
That was their cost of enforcement based on timesheets provided by the 2 or 3 zoning staff and Ms. Sturdivant, yes.
You agree the use as a gas station has been abandoned?
I do, Your Honor, yes.
And do you agree that the use as a parking lot is an unpermitted, non-conforming use?
I do, and that has been terminated as of the time of the hearing in this, hearing with Judge Durkin in this matter. So there's no parking on the property now. It's basically, you know, it's a vacant building. You know, the Judge Durkin, in his decision, his penalty calculation involved the fact that there was visual blight and graffiti on the building. This, you know, these items were never alleged by the city. You know, my overall point is that the court, the environmental court, went over and above what it was allowed to consider for a penalty, particularly with the 2004 agreement, and then talking about visual blight and graffiti, when it also admitted, as I said, this was a violation with really no impact. Any other questions? Thank you.
Thank you.
Yep.
All right, thank you. We'll hear from counsel for the appellee, please. Good morning.
Good morning, Your Honors. May it please the Court, my name is Kimberly Sturdivant, and I represent the City of Burlington in this matter. I'd like to start out by just addressing a few things that were questioned to Attorney Hare. First, regarding the 15-year statute of limitations, that's really not at play here. The agreement from 2004 was actually a June 16th, 2004 agreement. The notice of violation was issued April 5th, 2019, so it was issued within the 15-year time frame. So it was issued before that would even trigger. Plus, there's other issues like that regarding the potential of the 15 years for, there were some arguments about it applying to the leased out parking. And as we stated in our briefs, the parking that was going on there would have been, one, very hard to discern from the other use of the property. So it wasn't something that was obvious. It would be considered clandestine under the rules around the 15-year statute of limitation.
But wasn't it undisputed testimony that there was rented parking spots and that the original agreement was that they had to preserve space for the cars that were being utilized by the service station?
The city's record, the permits that the city issued, were not aware at all of the rented parking, if there was any going on at that time. The permit that was issued for expanding the service station had on it that there was 18 required and 18 provided spaces for that primary use of the lot. The appellant's prime only witness and one of the principals of Sisters and Brothers did testify that he had continuously rented, thus going against the argument that we didn't establish that there was continuous violations at the property during the time frame that the notice of violation was issued.
I'm having a little trouble with a couple of things here, and perhaps you could straighten me out.
Sure.
As I understand it, the DRB did not address violations of the 2004 agreement in its decision, correct?
They did not explicitly do that, no.
Okay, that's my first point. Secondly, I was unable to find any evidence that the city challenged the owner, Mr. Handy, or Sisters and Brothers, on compliance with the 2004 agreement between the time it got recorded in the land records and the time the gas station operation stopped in 2017. Do you agree?
I agree that was not in the record, correct.
Okay, but yet the Environmental Division uses the 2004 agreement and violations thereof in its calculation of the penalty under the record of compliance. So my question is, how can there be a record of compliance if there's no record of non-compliance? I just don't understand. The city didn't do a thing for 13 years, but it's okay for the environmental court to consider those violations during that period of time? Where am I missing something here?
Well, it is, Your Honor. It was one of the factors he took into consideration. There were a number of them. He went through the whole Uniform Environmental Enforcement Act criteria, and it was one of the factors that he took into consideration for the fine. Also, a
I
property owner...
understand he did, but why is it okay? That's what I'm
Because a
asking.
property owner is, their duty is to follow the law. He had an agreement, he was aware of the agreement, and should have been following it.
What do you mean he had an agreement? He never signed the agreement. It was never signed by him and filed by the seller. How could the court presume he was a party to that agreement and presume even his knowledge of the agreement?
So there was testimony at the hearing that the property owner had been talking and working with the prior owner for like a year beforehand. And there also was testimony, there was a requirement in the agreement to make sure that the new owner was aware of that. And an agreement runs with the land.
A contract like that?
One like this regarding zoning enforcement and yes.
Couldn't the court have as easily presumed that the seller didn't tell the buyer about it? Because it would have clouded the title and made the closing less likely and maybe filed it after the closing took place? Isn't that as equally plausible?
I believe that the testimony and the information I already talked about so far, even this morning, was that it was filed basically the same day. I have to verify that, but I So I believe it was at least known of on that day in the land records. And
Well, if it was done after the closing, if it was recorded by the seller after the closing, then the buyer would not necessarily have any knowledge about it. And plus, it's requiring an attorney to go do an update of a title search immediately before the closing in order to clear title.
I appreciate that that could be complicated. My understanding is that they had worked closely with the buyer and seller for many years beforehand, and that there was a certain agreements in place between them.
That's not in the record, though.
That is not in the record. It may be in the testimony of Mr. Handy. That, if I recall, I believe that was in the testimony of Mr. Handy, that he did work with the prior owner for at least a year beforehand.
Ms. Sturdivant, can you tell me how the consideration of the 2004 agreement impacted the monetary value of the fines against brothers and sisters?
So, yes, I'd like to. I mean, I believe it only paid a small portion of it. I think it was really just a matter of acknowledgement by the court that there was a continuous pattern of noncompliance. I mean, the significant portion of this case is the fact that the city had sent a warning letter to this property owner back in, I believe, 2008, letting them know that we had received a complaint and there was a concern about the parking. Then there was a notice of violation sent in 2019. And the owner appealed that, but then after they did not prevail at the DRB, they continued to do what they were doing. They continued to violate the ordinance for years. And Attorney here mentioned the photos in only 10 days. I think it's been stated by this court, you don't have to prove every single day of a violation to prove it's continuous. If you look at the times of those photos and the amount of cars parking there, it is a significant violation. And those dates of the photos go from 2018 to 2021. So it's a whole 3-year span of just kind of showing the repetitive, continued violation.
But there's no monetary value that you can isolate for me that delegates what is reflected in the fine from that 2004 agreement and if there's noncompliance?
I don't believe there's like a monetary no, I don't believe so. I think the factors, it was a factor to show the continual noncompliance. Other factors had to do with the fact that, he was getting paid for this parking, $150 per car per month.
Yeah, that's what I wondered if maybe it related to what he was collecting for rental spaces.
That, I'm sure, was a significant part of it.
Right.
And there was no evidence of any abandoned cars that being used on the parking lot or something that would cause some environmental harm by having cars there that were leaking gas or oil or the rest.
I don't believe we saw that from the exterior cars. There were sometimes cars in the bays that were just sitting there. But, the other impacts, the environmental court also noted the impact of, the not being able to use this for a use that's allowed in the district for 3 years, that it was being used by, a parking lot is not an allowed use in the RH district. And a parking lot is a use in the use table of the ordinance, and it is not in this district allowed. Also, just the blight, and you can see in the pictures, the property has not been maintained during this 3 years, and that also has an impact on the neighborhood.
Was there testimony about the 2004 agreement before the DRB?
I believe there was testimony. I'm trying to think back because I was at that hearing, but it was a little while ago. But I think there was some about it. The difficulty is the use did, stop in 2017 that the agreement was about. So that prevented or made it a little bit more awkward, but at the same time, the landscaping and the site changes should have been done anyways and should have been maintained until a new use came along.
And why didn't the DRB address the 2004 violations in its decision?
I believe they were more focused on the parking and felt it was more of like a contract breach than maybe something that they were, concerned because the use had changed.
And I lost my train of thought.
Sorry.
Oh, no, it's gone again. It may come back.
Just make sure I've covered everything that,
Did come back.
okay?
Do you agree that the 2004 agreement is now moot?
I don't. I believe the landscaping and the site improvements should have been taken care of. Right now, you have a parcel that has pretty much no vegetation. All that was supposed to be done. Some of it was done, but then, not maintained. So I
On this
believe that
part of a gas station or a service station,
Yeah.
that was the whole point of having to sort of put the flowers out and the rest. That's to sort of make the gas station look good. But once it's abandoned as a gas station, does it make any difference?
You still have a property that had an approved site plan, even if it's connected with that use. But ultimately, I believe, from what is before you, the purpose of the agreement and the discussion really is more just the continued showing of noncompliance and egregious behavior, which goes towards the amount of penalty that should be, the fine that should be instilled.
And the penalty was more than you asked for in the environmental hearing?
We had requested as part of the penalty our costs, because that is typically, one of the factors that it is based upon, and whatever other relief that the court felt was appropriate. And I certainly agree with the court that $50 a day out of the 200 potential is appropriate in this matter, given the length of the violation and the nature and the fact that the property owner was receiving a lot of benefit from it.
What is the length of the violation?
It was at least from, the time of the warning, which was in 2018, July 5th, 2018, through until at least the date of the hearing in 2021. I understand that they had stopped that. It was reported at the hearing timeframe. I have seen a couple cars there since, but it was all past that timeframe. So, but as far as the fees go, you would not be able to take the, you don't start counting the money until after the notice of violation. So from approximately April 11th, 2019, till at least through the date of the hearing in 2021.
Could cars just park there without a permit, or just, driving downtown Burlington, you're looking for a spot and say, oh, that place looks good, and just pull in?
There's nothing that is around the property currently that I'm aware of to prevent someone from pulling in there. Let's make sure I've covered. I think you've covered everything. Thank you very much.
Thank you very much. Thank you. How much time does the appellant have, please?
Appellant has 1 minute and 26 seconds remaining.
Counsel?
Your Honors, the Title 24 says that every day a zoning violation exists is subject to a penalty. It's a separate violation. They pile on day after day. If you build a house in the wrong place, in the wetland, it's a static structure. If you see it in May, it's probably still going to be there in September. A parking lot, it's a transient use.
Didn't we address that issue in Ray Jewell?
I think you did. In that case, that was already an established parking lot. But you're right, Your Honor, that case did not require a daily inspection. But the thing here is, city staff testified that there was no parking during the weekends. Now, how many weekends are in a 365-day year? How many weekend days? Maybe 100, give or take. And this is a 3-year violation. So, in theory, the environmental division overestimated the 852 days by possibly 300 days. So
But Jewel says we don't have to look at each individual day, right? It says to prove a continuing violation, which this seems to be, you don't have to count each day when a car is there. And I think in Jewel, it was a really lengthy period of time, years, and the city or state, I can't remember which city, only went there 11 times during that whole period and took pictures or took notes, and we said that was okay for a continuing violation.
I'm seeing my time is Your Honor. I would just say that, please consider the fact that city staff said at trial that the lot wasn't used on weekends. So at the very least, the calculation was incorrect in that regard.
Okay, thank you very much. Please call a conclusion of the hearing.
That concludes today's hearings.